That's about as mad as you'll hear Matt Kuchar get.
That's a sign of a man with young children.
Put $1 in the Kuchar swear jar.
Rachel McDuffie for the people.
Thank you and good morning, Your Honor. Joseph Hall appearing forward on behalf of Mr. Varney, who appears via Zoom. I see him logged in there. Mr. Varney, if you could unmute, turn your video on, and say your name for the record, please.
Joseph Leonard Varney.
Thank you very much. Your Honor, we are here today for sentencing. To that end, my client and I have reviewed in full the pre-screening investigation report. There's only one correction to the sum and substance of the report that we would propose, and that is in the section headed substance abuse on page 2. It indicates that the reason that Mr. Varney has never used any controlled substances is that his brother died from an overdose when he was 18. In fact, it was his father who passed away when Mr. Varney was 18, and that is the cause for his lifetime sobriety from controlled substances. Other than that, Your Honor, we have no corrections, additions, or deletions to propose to the body of the report.
Thank you, Ms. McDuffie. Anything regarding this particular sentencing? I just echo the concerns from probation in the PSI. It doesn't seem as if I just don't know if the relationship that Mr. Varney had or has with his children is coming through there. Even in the end where he's saying now I have this case because this stuff happened, and he didn't seem to, and I don't know what relationship he wants to have moving forward. I understand that right now, I don't, in the interest of safety and everything else and healing, I think for everybody involved, that there needs to be separation. But I'm just a little bit confused about obviously why, but how this incident happened the way it did. And I don't know what to say about it other than I agree with probation. This anger management has got to be a start. It seems like there needs to be a lot more, but I guess one thing at a time. That's all I can say.
And Your Honor, to that, I would say I think confusion actually kind of makes sense to be Ms. McDuffie's stance here. One area that we have to understand that we occupy right now is that this report was drafted by virtue of the police report only, as stated from and Mr. Varney's statements to Ms. Johnson. There was never any contact made, and Mr. Varney and I, to be honest, I think from Mr. Varney's end, we really wish that contact would have been made, because a lot of the confusion is coming from the fact that we're trying to glean these things from a police report and Mr. Varney's statements to Ms. Johnson. Your Honor, this incident in and of itself was very confusing, to the extent that at the end of the incident, after the officers had all arrived and right before Mr. Varney was taken, 2 out of 3 officers were in the huddle. And it's on video that Miss McDuffie has, that I have. 2 of the 3 officers were arguing that nothing should happen to Mr. Varney, right? And so I don't want the extent of this to be overblown because we're trying to glean things from words on a page that can't be asked questions or followed up on or what have you. Mr. Varney, to his end, wants a full relationship with both his children. And he made great efforts to actually get a relationship going with his daughter in recent times. Additionally, Your Honor, there has been not one other incident in Mr. Varney's entire life of any sort of problems within the home, or certainly not violence. this was an incident, Your Honor, where Mr. Varney was awakened out of sleep to somebody trying to kick his door in. Now, regardless of, I can't imagine, I've never had to do that, Judge. I imagine that's startling in nature. The tussling that comes after, that's confusing in and of itself. But I think confusion is a good word to sort of describe this case. By no means do I think it means there is some habitualized pattern of activity or something full scale that we can talk about Mr. Varney's relationship with his children. For 99.9 and go on to decimal points of that relationship, it has been fantastic. The children are successful when they live with Mr. Varney. Tyree, the young man who is the subject of this charge, is in college, is doing positive things, having grown up and been tutored by Mr. Varney. His daughter Shayna has been succeeding more in her life in the time she has lived with Mr. Varney and his wife Chelsea than ever before. So, Judge, yes, this is a regrettable and certainly confusing incident, and Mr. Varney has owned it, Judge. This is not. I'm not backpedaling away from culpability, but before we go and make this something beyond what it is on the page, an assault and battery, I think I wish we could have had contact with the children to fill in the blanks here before we assume on a confused basis that there's something much deeper here that requires something much deeper. I think that goes too far, Your Honor. What I think the record supports, I think the recommendation is essentially fair. I was actually going to ask that Your Honor consider less probation on this case. Mr. Varney does not have a significant record. He has the support of his wife. He's doing positive things. He never violated one iota of anything while on bond, and I think he's a good candidate for that. As it stands, I think Mr. Varney is the type of defendant who will succeed no matter what obligations Your Honor puts on him. But I just want to push back against the idea that we should read between the lines here, and then what we find between the lines we should hold against Mr. Varney. And I guess I would leave it at that, Judge.
I'm going to respond just a little bit to you regarding the statements that you made. Ms. McDuffie probably has things she wants to say, but at this point, I'm going to put it like this. You are referring to the fact that we're trying to read between the lines. This is not a reading between the line type of scenario. This got completely out of control to the point where his son thought that his father was going to kill him. Now, I'm not saying that I fully understand what happened before those feelings and that part of the incident was occurring. I don't know how we got there. That's the problem. You know, you have a daughter who says that her fingers were slammed in the door based on the police report. And then you have a son who at no point in time says he was kicking on the door, but rather his father came to the door and actually grabbed him and threw him into bushes. I don't know what happened. I wasn't there. I accept your proposition that the police officers were confused and couldn't initially figure out who they thought was the aggressor to charge in the situation. I can accept all of that. But to try to recouch it as a simple A and B, that it is not. That it is absolutely not. We have him with Mr. Varney with black eyes. We have him being hit in the head with poles. This was a melee of a mess. And I completely accept that Mr. Varney has had no issues before. And I believe, I don't pretend to speak for Ms. McDuffie, but I believe her concerns align with mine, which are, how is the healing process going now? And what is going to be put in place to ensure that they are okay for their forever lives? That is what I think she's referring to. And that is the concern that I have as well. As I read this report, I tried to go back and see if I could figure out who was the aggressor, because when I read what Mr. Varney said, I get very concerned about how this came about. If you have a father who is trying to be a father and set curfews and you have kids who are not abiding by those curfews, who decide that they will come home when they want to come home and the door is shut and then they're trying to kick in the door, that's one scenario. If you have a scenario according to what the daughter says, where no one's kicking in the door, but Mr. Varney is not behaving in your normal parental manner and being very aggressive, that's a different scenario. And that's where the confusion is. Having said all that, Mr. Varney, because I'm still confused, what would you like to say, sir?
Thank you. I'd like to start with an apology to my family, to this courtroom. It was never my intention for the events of that night to escalate in the manner that they did. I've been without my children in my life for almost 5 months now, and the hole in my heart and my soul from that is pretty undescribable. I've managed to stay out of trouble the majority of my life, so this situation I find myself in today is unfamiliar and terrifying. Just moving forward, I want to vow to my family to never find myself in this situation again.
And I believe what you're saying. I hear your pain.
Thank you.
So our goal now is to try to figure out how to create a you that this wouldn't happen in the future for, and for your family. So that's what this is about. I think that the time frame that we're looking at for the A and B is sufficient and it's adequate in the right amount of time. It's an A and B, so therefore you would be eligible for an early discharge when you complete half of that anyway. There was just so much going on out there. I'm glad to hear that your children are doing well right now. As far as their careers are concerned, or the start of their careers, that does not say how they're doing emotionally, though. And you probably don't really know, and that's probably very painful too, because you don't have the ability to know. I'm going to follow the recommendation, and I hope that at some point we can have a scenario where maybe everybody's in counseling so that you can move forward as a family. Well. I'm sorry, sir.
I said that is my hope as well.
Yeah. All right. It's the sentence of the court that you serve 93 days in the Washtenaw County Jail. Credit for 1 day served. 92, the balance of that is suspended, so you never have to do any additional jail time, sir, if you do what you're supposed to do here and trust the process, Ms. McDuffie, is there something you wanted to say?
I wanted to let you read the terms. I just had a question about if there was any specific order in which, because counseling was ordered, ABR was ordered, and I didn't know if Agent Johnson intended for him to do any one thing before he started the other.
All right, thank you. You're on probation, sir, for 18 months. Fines and court costs in this case for $525, $30 per month probation oversight fee. Meet with probation when and where directed, including any and all home visits. make earnest efforts to maintain legitimate employment, complete the ABR Domestic Violence Intervention Program, Early Intervention Program, and engage in family counseling, sign a release of information. No assaultive or threatening behavior towards anyone. No contact with Shayna Varney or Tyrese Varney Bush. Submit to and pay and be responsible for random drug and alcohol tests as requested by the court, probation, or any police officer or treatment provider. No use or possession of alcohol, marijuana, illegal drugs, or drug paraphernalia, and no be in the presence of anyone using those or firearms, components, ammunition, or other dangerous weapons. I'm going to do a review in 45 days. The way I think this should work, sir, is you go to the early intervention program. I think they do an assessment and determine how many classes you need. And then once you've done, started that particular program, you can start the counseling on your own. And then I think the counselor should be the person who sort of figures out whether or not it's time to begin the reintegration process with your children. So the sooner you do that, the sooner you can start to see your children if that's what they want. You know, you have to give them the space to figure out what they want to. And I too, along with Mr. Hall, wish that we were able to reach them. So I don't know if they may be watching online or what, but if they are, I hope they reach out to probation so we can get a better feel for where they are with what they want at this point in terms of contact with you, Mr. Varney.
And Your Honor, I'm confident that will occur in the future because I believe Victims Advocates was having regular contact with them throughout the pendency of the case. So I'm really hoping this isn't the no contact or the inability to make contact isn't something that continues because like you both, I agree that getting people back in the in communication is part of the healing process here and will eventually need to take place.
Right. And, you know, if they reach out to the court or to the prosecutor's office and indicate that they want that contact, the court will be notified and we'll try to start that reintegration process.
Thank you, Judge.
You're welcome.
Your Honor, there is one final issue today. I know my office tried to start communication back in February about a potential travel request for Mr. Varney. Mr. Varney, for a long period of time, has been a high-ranked amateur golfer in the United States. At one point, he was 9th in the country. He actually has a golf tournament beginning in Los Angeles, March 15th. He would actually get on a plane today, the 14th, and return on March the 18th, if allowed by the court. That was something we informed Judge Barr about, but given that Mr. Varney was going to see you today, Judge Barr deferred the decision and to Your Honor's court. We did send a travel request, as I said, on February the 26th, but we have not yet heard back.
Typically, those are provided to me, so I'm not certain that it went through properly. They used them over to me. Defendant, is there any objection, Ms. McDuffie?
No objection, but you said it's in LA starting tomorrow?
It's in LA starting tomorrow, the 15th. He would leave today, get on a plane today. But he has already purchased the tickets and at his own risk.
The tournament, I believe, is the 16th, Joe.
The tournament is the 16th?
The 16th, yes.
All right. I'm looking at the email from my secretary that says it begins the 15th, but I appreciate you correcting the record. Mr. Varney, is it true that you would get on a plane today, though, to leave?
Yeah.
Okay. So it would be the 14th to the 18th
Yes,
you would not be within the jurisdiction.
Yes, sir.
Thank you.
Same return time, yes.
Anything else from you, Ms. McDuffie?
Nothing from the people.
I'll approve that trip.
Thank you, Your Honor.
I can send that to him here shortly, Your Honor, if he wants to send me an email to that effect, and I can get that to him once we finish court.
All right, thank you. And
Thank you, Ms. Johnson. Good to see you, Ms. Johnson.
You're welcome, Mr. Hall. You're welcome, Your Honor.
You need to reach out to the probation department anyway so that you can go over and sign your contract. And so if he's leaving today, Are you gonna do the travel request and do the contract when he returns? How do you want to do that, Ms. Johnson?
I can do the travel pass today, and then we can go over his contract when he gets back from his golf outing.
All right, so contact the probation department this afternoon. You have that number, sir?
I'll have my staff reach out to Mr. Varney immediately after the hearing, Your Honor, and
All right.
provide with all the contact information.
All right, and then I don't think I set the review date, so I think I still need to do that. We'll do a review in this case on May 16th, 2024 at 10 a.m.
Thank you very much, Your Honor.
Thank you.
Thank you, Your Honor.
You're welcome.
Take care, everybody.
You too. State of Michigan versus John Garrett, case number 23 FB 1294.